Hi, this is Kurt Barone, and welcome to another edition of Fire Law Roundup.
Okay, let's go to Arizona. Look, I don't want to be critical, but this is a stupid lawsuit. And I think I found what you're referring to where you can't find the 1983. I may have found it for you. But in any event, so we have, very sad. We have a woman who died in a fire in Coolidge, Arizona, right? And her family is suing. I get it. Everyone thinks you should have responded faster, you should have done better, you should have got there sooner, you should have, tried to resuscitate, all these things. But some of it's very confusing based on the alleged facts, the time records, which shouldn't be up for debate. So what happens is there's a call that goes out at 0340, right? So we're talking 3 in the morning, not 1500, right? But 0340 hours. So at this time, it is a volunteer staff, right? The career is daytime and it's volunteer at night. So according to the fire incident report, the department's dispatched at 3:52. Now, 12 minutes is a long time. That shouldn't happen, but I don't know why it happened. And, that's a different issue, right? It's apparently not here. But then there's an on-scene time of 4:05. So, we're 13 minutes later on scene, which all in all isn't the worst thing. Volunteer response at night. They're probably coming from home, according to this. And I don't know how far away the house fire is, right? But they say pretty close. In any event, 13 minutes to most volunteer fire departments. What's the NFPA? Like ideally 15, a 10 minute, 15?
15.
Okay, so there.
Well, you got to assemble. I think it's 15 people in 15 minutes, something like that, or 16 people in whatever it might be. But. So they made some claims that it was took 40 minutes to get there. It's very weird what they said, because that part is where they that this was a pro se. This was a pro se. I know it's kind of hard to see it, but it's a pro se lawsuit. And I think that explains a lot of it. For those of you who aren't familiar with the term pro se, that means the plaintiffs couldn't find an attorney to take the case. Right. And filed it by themselves. So it's a little like an unarmed person going up against somebody who's got a Glock.
And right. And they're going to, or frankly, an AR-15, because that's what they're going to be met with. This is going to get dismissed on the public duty doctrine and qualified immunity and all that. But nonetheless, and we won't spend too much time on it, but she tries to say negligent hiring, negligent supervision, negligent training.
For pro se suit, it's actually
pretty good.
Well, yeah, pretty good. Yeah.
Maybe she used ChatGPT to write the complaint. Who knows?
Could be.
I'm going to try that, actually. That would be interesting. So,
what about Zach? You're going to put Zach out of
yeah, right. That's true. No. Sorry, Zach. We're not going to do that too. So, I don't know why. I mean, I have an idea, but I don't know why the state has moved, or the city has moved to try to get this to federal court. I think I found out why, because she alleges the policies and customs and practice, or lack thereof, of the city and the fire department were the direct damages. So maybe there was some ongoing practice, but unless it's like some ongoing practice where we don't respond to women in burning buildings, I don't know. I don't get it, but and we shouldn't spend too much more time on it, except to say, I'm surprised they didn't just move straight off the bat, say, there's no proof. She doesn't make a prima facie case of anything.
Right. I would say I agree with you. Let's not waste a lot more time on it, other than the fact that I can't tell you how many people have contacted me over this case.
Really?
Yeah. I mean, just asking questions does this mean you can't have a volunteer fire department? What if, you had paid people, but you don't keep them? A lot of questions. Right. Personally, I don't see this case going anywhere, even if they had attorneys. And I think that's one of the reasons why they probably didn't file it with attorneys, and the attorneys looked at it and said, you really don't, there's not a lot to go on. We understand you're upset. We understand you feel the fire department could have done more, but they responded. They're not under a legal duty to get there within, say, 4 minutes or 6 minutes or 8 minutes. I think there is that gap you said, and I'm not sure. I'm sure when they do the investigation, and maybe Other people know why. There was a delay between the way that the police handled it, or when the police took the call, and when it got transferred over to fire. Could be, sometimes you have clocks differently in the different dispatch offices, and they're a couple of minutes off, and depending, that can explain some of it. But at any rate, there's just not a legal duty that was owed to the public that is going to be able to get past, I think, a motion for summary judgment, or possibly even a motion to dismiss. And also in the removal notice, the fire department, the city, said that they have tried to reach out to the plaintiffs, and the plaintiffs are refusing to contact them.
Which, yeah, one of those things that surprises me only on this. There's usually what's called a notice of a claim or notice of intent to sue a municipality. Now, this was a year and a couple of months ago. All right. So normally, I don't know where Arizona's laws, but if this was New York, now the person died. So you would generally in New York have about a year from the time the estate representative was appointed. All right. So maybe that's what happened, but that's a lot of process. Right. So I'm surprised that at least the city doesn't seem to think that the plaintiff has messed that up, and that they've got the notice of claim right or all that, because usually with the notice of intent to sue, where you have to say, listen, I'm giving you notice within 90 days of the accident or the injuries or the death or whatever that I'm going to sue you. And the municipality has the right to conduct a deposition. And again, I don't know the laws in this state, at least in New York and many other states, they have the right to conduct a deposition. Right. Even before the lawsuit's filed. So to say we're having trouble getting a hold of you, well, wait a minute, they could command her to appear at a deposition either before or after the lawsuit's filed. So I was surprised about that.
Yeah, and I wonder if there's a little bit of a shell game going on with the attorneys here, because if you figure that these people are refusing to take the calls and emails or whatever from the city on this to discuss it, saying screw you, we're not gonna give you the time of day. But then at some point they're going to go to court, and they're going to go to the clerk and say, hey, we want to, and they're going to say, your case isn't here anymore.
Right. And federal court's very tough to practice pro se in, because they're very strict, right? I get it as a procedural, we're going to make this so hard on you, but why not just try to get rid of it on motions to dismiss and then move? I don't know. So, but no, I don't think people should be worried at all that we didn't get, look, you do what you can do. I'm not excusing, of fire department for saying, well, we got 80 names on the list, but we know that there's nobody here. That has always been my thought on liability, where you say we knew in advance we didn't have enough people and we hoped they would show up, but we had knowledge they weren't. To me, that could be a claim for negligence. You're still not going to get around special duty that I don't owe any individual, but that could be there's probably no special duty, one-on-one relationship, that type of thing. But that would still be negligence, right? I know that nobody's going to show up because I got nobody in my fire department, and I'm telling you nobody's going to show up, or I should have known, and I misled the community hoping that if we had a fire, somebody would show up. I don't know. That would be my basis for worry. That's not this case.